Thank you very much, everybody. Our second presenter, as you know, is Bill Rimmer, another property law expert. I think Bill's been acting and practising in property law for close to 25 years without a break. So that says something about Bill, I'm not sure what. Please, Bill's topic, I think, is in Sale of Land Act update, is recent cases. Is that correct, Bill?
That's right, yes.
So please welcome Bill Rimmer.
Thank you, Michael. I apologise for being a little late at the start and holding you up. I can only account for it by the fact that I was at the opera last night and I'm still reeling in shock from finding out that she dies in the end. My part of today's presentation is to romp through a few recent cases. One of those cases, which is now not quite so recent, one of those cases which is very recent is a decision by Justice Gard that confirms Justice Dixon's decision in the original Otterden case. Now, David referred to both these cases in passing in his presentation. I'll just point out that the reference to Justice Gard's case is amongst the cases in my handout, and the decision of Justice Dixon, the original decision, which is Otterden and Portbury, is now reported in the Victorian reports. So famous is it? And just to, and on page 1 indeed of the relevant report, which is 2011 35 Victoria Reports, page 1. So for those of you who would like to follow those cases up in the reports, that's where you'll find them. I'm going to take the Act section by section, that is to say those sections which have been considered by recent cases, and see how these cases illustrate some of the principles. So the first of the cases is about section 9AA of the Sale of Land Act. It's a case of RDN Developments and Strambrandt, decision of Justice Croft. And this is really a case that's about the removal of caveats. But in the course of that, Justice Croft considered an argument that the relevant contract was a prescribed contract and the vendor had not complied with section 9AA of the Sale of Land Act, and therefore the contract was illegal and void. So it was an illegality argument, and Justice Croft was able to deal with this in short shrift. He pointed out that where the requirements of section 9AA are not complied with, and the contract's a prescribed contract, namely a sale of a lot off an unregistered plan, the contract's not void for illegality, it's not unenforceable. Rather, the Act itself provides the remedy, which is under 9AE1, to make the contract voidable at the option of the purchaser. So, the purchaser is perfectly entitled to enforce the contract, if it wants to, and the purchaser also has the right to avoid the contract, but only, of course, up until the time that the plan of subdivision is registered. Second case, also on 9AA, is a county court decision, which is again provided by way of illustration. This was a case where an agent paid away the deposit before registration of the plan to the vendor, and Judge McInerney stated that an agent receives a deposit from a purchaser under a prescribed contract on trust for the purchaser until registration of the plan of subdivision. So the effect of the section that requires the agent to hold it on trust for the purchaser until until registration, has the effect that the agent receives the deposit on that basis. Before the plan of subdivision is registered, Section 24 of the Sale of Land Act has no relevance. So the agent is not holding pursuant to the stakeholder provisions, is holding pursuant to the 9AA provisions. So if in breach of that trust the agent pays a deposit to the vendor, then the purchaser becomes entitled to equitable compensation. So that's an interesting decision. It's one that I would respectfully endorse, and it provides, I think, some guidance to us as practitioners as to how to analyse the obligations that are imposed on agents and solicitors, for that matter, when holding deposits under sales contracts for the sale of land off a plan of subdivision. Moving to section 9AC, this is the section, of course, that deals with amendments to the plan of subdivision. Case of Besser and Alma Holmes, it's a decision of Justice Pagoni in 2012. This decision, of course, is now well known, but it's still recent enough to appear on my list as a recent case. This was a case where a vendor of apartments off the plan amended lot entitlement, lot liability, attaching to the lot sold. So it was amended from 1 of 202. It was amended to 1 of 202 rather than 100 of 400. The purchaser didn't discover this until after registration of the plan, when the owner's corporation information was obtained from the title's office. And so the purchaser rescinded under section 9AC. And Justice Pagoni held that the word plan in the section has its ordinary meaning. It doesn't just mean strictly and literally the plan of subdivision which has the number on it. It means also the totality of the scheme of arrangement by which the property is to be subdivided. And so it includes respective rights and obligations which were attached to each of the lots. I think it would be interesting to see how the cases develop, whether any widening of that concept is attempted using Justice Pagoni's analysis of what the plan of subdivision is. Because one could imagine that many other things, not just lot entitlement, lot liability, might be described properly as part of the scheme of arrangement by which the property is to be subdivided, and the respective rights and obligations which are to attach to each of the lots. But the other part of the case was that it's not to the point that an amendment might benefit the party that's seeking rescission. The section doesn't restrict relevant amendments giving rise to the right to rescind to those which are adverse to the purchaser. Of course, it does restrict it to those that are material, so those that materially affect the lots. So the fact that an amendment benefits the purchaser who's seeking to rescind the contract might be relevant to the determination of whether the amendment materially affects the lot. But that's a question of fact, and that's to be determined by reference to objective facts and circumstances. And as we know in that case, it was held that the change was material and the purchaser's rescission was valid. Now, another decision considered and applied Justice Pagoni's analysis, This is a decision of Justice Judd last year in the case of Lockwood and BSP Investments. This was an interesting fact scenario. Largely it really was a case that turned on construction of the transaction as it had been structured by the parties. Because what happened was that the purchaser bought 4 apartment lots and 4 car park lots under 8 separate contracts. And then the vendor amended the plan of subdivision to wipe out the car parks and sought, I would think rather cheekily from a commercial point of view, to enforce the 4 contracts for the apartments and say, well, you've lost the lots, the car parking lots, but you've still got an obligation to go ahead because they're separate contracts. You see, they weren't interlinked in any way. There was no express condition making settlement under one conditional on settlement under another. What Justice Judd had no trouble in finding was that these were in fact sold as packages. Namely, there were 4 packages, not 8 separate contracts, and each package contained 1 lot and 1 car park. So the deletion of all of the car park lots and the inability of the vendor to complete those contracts materially and adversely affected each apartment lot. And the purchaser thus validly rescinded those contracts under Section 9AC(2). In the course of that, Justice Judd expressed the view that the decision in Besser was correct in law, in his view, and that the amendment need not be detrimental in order to trigger the purchaser's rescission right. And secondly, that Section 9AC, unlike Section 9AB, which relates to the disclosure of works, doesn't limit the purchaser's right to rescind to a time before registration of the plan. You see, we all know from bitter experience that a purchaser often doesn't find out that a plan's been amended if the vendor hasn't complied with its obligation to notify the amendment until you're right on settlement and you search the plan, and lo and behold there are substantial changes to it, material changes to it. So your right to rescind in those circumstances continues despite the fact that the plan's been registered. Another decision, JD number 6, Daver and P. Batley Holdings, is another decision of Justice Croft on Section 9AC. Really the comments that Justice Croft made about Section 9AC were obiter. Because what happened was this, that the vendor and the purchaser entered into an option agreement, and the vendor agreed to sell to the purchaser the property off the plan, and the plan of subdivision that was agreed would be the subject of this contract was attached to the option agreement. Before the option was exercised, the local municipality issued a permit for the subdivision, but in that permit it required changes to be made to the plan of subdivision. Purchaser exercised the option and then discovered, when the vendor issued the contract to the purchaser, that the plan attached to the contract was different to that attached to the option agreement. The ratio in the case was that Justice Croft held that the contract provided by the vendor after the exercise of the option was not in conformity with the option agreement, and so there was a total failure of consideration. For that reason, the purchaser was not obliged to continue with the contract. So on that analysis, no question of rescission under Section 9AC arose. However, he did go on, helpfully, to express obiter that the amendment in any event was one that was requested by the vendor. See, the vendor had said, well, this wasn't requested by me, this was required by the municipality as part of the planning permit. Had no trouble in saying that, well, the planning approval process is in the hands of the vendor, and the role of the council is simply to issue as part of the planning process to say, well, we will approve or we won't approve, or we'll issue on conditions. But the vendor's got the option then to either accept or object and appeal, or to accept the council's requirements. And if the vendor accepts the council's requirements, then that constitutes a request by the vendor for the amendment to the plan, or it amounts to it. There are also policy arguments that he relied upon to reach that conclusion, because otherwise there would be a lacuna in the section. Section 9AE2 has been the subject of a number of authorities over recent years, most importantly Solid State Investments and Clifford. This decision was recently affirmed, applied, approved, sung with the highest accolades, quoted by the subsequent Court of Appeal in the cases of Harrafam and Sherman and Harrafam and Allen. So these two decisions confirmed the law in Solid Investments and Clifford as expressed by Justice Mandy, or Appeal Justice Mandy, in the Court of Appeal. A prescribed contract specified that the plan of subdivision was to be registered within 24 months of the day of sale. But it had one of those conditions. It said the vendor could extend this period, but this condition was a little different. It was very limited, and it was limited in two ways, relevantly. One is that the extension could only be made once. In Clifford, the relevant extension could be made any number of times. And secondly, the extension could only be for 6 months. So it was limited, it was subject to a maximum, and the maximum was specified. Naturally, the vendor argued that this was the specification of another period, notwithstanding Clifford. And the Court of Appeal had no trouble in holding that. Nevertheless, although it is limited, it still contained the same difficulties, particularly from a matter of policy and the purpose of the Act to protect purchasers and provide certainties. A dispute could arise between the vendor and the purchaser about whether the delays had occurred as a result of matters beyond the reasonable control of the vendor. And so the right to extend the period is still calculated, despite its limited nature, to deny the kind of certainty to the purchaser that Section 9AE2 was evidently enacted to create. Now, moving along, this time to Section 23 and the definition of deposit monies. I've just alluded to a decision by VCAT in its legal practice jurisdiction against a practitioner who had received a holding deposit, and the allegation was that the holding deposit had not been dealt with as a stakeholder in accordance with Section 24. And a holding deposit means money, of course, that a purchaser pays to hold the property. It's not given as a deposit under the contract. So the purchaser had given $2,000 to hold the deposit and then had paid another full deposit under the contract later. So there was an additional $2,000 that was held that had been paid initially simply to hold the property. And VCAT determined that this kind of holding deposit was not deposit monies within the definition of Section 23, and so the solicitor was not holding the that money under Section 24 as stakeholder, and nor was it paid to the practitioner as stakeholder under Section 25. However, the holding deposit was received and was required to be held by the practitioner on trust for both parties, nevertheless. So, obviously, the money is still trust monies. It's just not stakeholder money. The other decision on Section 23 is the decision in 2012 of Grant and Harlgate, Justice Beach. There, an agent held a deposit as stakeholder. The vendor went into liquidation shortly after the day of sale. The liquidator disclaimed the contract. Purchaser alleged repudiation and also rescinded the contract, so nobody thought the contract was on foot. Purchaser was clearly entitled to the money back, and the agent, without having any authority to do so under Section 27 or at all, paid his fees to himself out of the deposit and gave the balance to the registered mortgagee, coincidentally related to the agent. And the agent was held personally liable as stakeholder to refund the deposit to the purchaser who was entitled to it. Although this case seems blatantly obvious, and your reaction is the reaction of all people with a moral compass, one needs to remember that one of the features of this case is that if a stakeholder pays money otherwise than in accordance with the terms of the stakeholding, then the stakeholder will be personally liable to refund it. So that should cause us all to actually draw breath. Because, as we know, there are many traps and pitfalls in Section 27, and if one were to fall foul of one, for example, to accidentally pay a deposit, or release a deposit, even with a Section 27 statement, where there was a condition that inured for the benefit of the purchaser, which happens, people do overlook that. You might find, if everything went pear-shaped and the vendor was unable to complete and was insolvent, you might find that you will be named as the stakeholder. So we should be very careful. I mentioned briefly case of Benson's and IMMS Financial. This is a county court decision by Judge Kennedy. It's caused some very interesting lunchtime conversation amongst counsel who've had differing views and changing views over time. The counsel maintaining one of the propositions very forcefully, not being someone here present today. In other words, it's not either of us. But Judge Kennedy decided that Section 24 provides that nothing in Section 24 shall operate to prevent the transfer of deposit monies from an estate agent acting for the vendor to a legal practitioner acting for the vendor in relation to the sale. She didn't hold that. That's what the legislation says, I'm sorry. But what she said was that this exception doesn't apply only to transfers of the whole of deposit monies held by one stakeholder to the other. See, the argument had been put in that case, which involved many other issues, of course, that provision only authorised one stakeholder to transfer the whole of the monies. So the deposit monies meant everything that stakeholder was holding. You couldn't split it up. And she had no trouble in holding that there was nothing in that authorising provision that limited it to the whole of the deposit monies, and that it did permit the vendor's agent to retain part of the deposit monies in its trust account and transfer part to the vendor's solicitors. Now, this, of course, is something that happens all the time. So, my own view, for what it's worth, and with great respect to Her Honour, is that common sense prevailed in that decision. But this is something about which you can expect some discussion in a text that we hope will be appearing, Michael hopes, by the end of this year. We certainly hope that, because, as Michael mentioned, David and I are in the course of preparing a work on the Sale of Land Act, and this will be one of the issues that we would no doubt be discussing. So finally, and I'll make it the final case because we're out of time, is the case of Portbury and Otterton. This came up again in 2014 because the trial of the proceeding occurred only either late last year or this year before Justice Gard, and he handed his decision down early this year. And you see, the original Otterton case, which is of course now reported in the Victoria Reports, was a summary judgment application, and therefore, that having been rejected, the matter went through to trial, and the trial was before Justice Gard. Justice Dixon's analysis of Section 29A, however, was upheld. A contract providing for payment of the price by instalments, where possession was not to be given until after payment of the whole of the price at the final settlement, was not a terms contract within the meaning of that section. The reason for that is, as explained by David, to do with the definition of deposit that appears in Section 29A. Justice Gard also noted that the purchaser's right to rescind under Section 29O, subsection 2, for failure by the vendor to pay out the mortgage within 3 months of the day of sale, was precluded in any event because the purchaser had not settled by 3:30 p.m. as required by the contract, and only purported to rescind after that time. So a fax, I think, went out at around about 4:30 or something like that, exercising the right under Section 29O, subsection 2, to rescind because the mortgage had not been paid out, but the contract required that settlement occur before 3:30 p.m. So, as they say in the Herald Sun, that was a technicality. But of course, as we know as lawyers, those things are not technicalities, they're an essential part of the right that a person has. I just make one note, comment of my own on the consequence of the Otterton decision. It's now, of course, we hope, if the changes foreshadowed by David occur, that this will be consigned to the dustbin of history, and that instalment contracts which provide for possession to be given only on final settlement will once again become terms contracts regulated under the terms contracts provision. But one consequence of instalment contracts without early possession not being regulated under the Section 29 provisions is that the instalments, as they are received, become deposit monies within the definition of Section 23. So it's not true to say that it's entirely unregulated, but they become regulated as deposit monies, and therefore they have to be held by stakeholders under Section 25 and only released to the vendor in accordance with Section 27. And a consequence of this is that before instalments can be paid by the vendor and retained by the vendor, they must first be the subject of Section 27 statement. And my interpretation of Section 27 is that a fresh Section 27 statement would need to be provided for each instalment as it's received. That's because Section 27(1) only authorises the stakeholder to release monies it is holding under Section 24 with the purchaser's authority. So as it holds new monies, then it would need a new authority. As I say, a case may never arise on that point because we will return to common sense and have instalment contracts regulated as terms contracts.
Thank you, Bill. It is getting close to 5 to 9, so I understand that people need to leave. But if you would like to ask questions and discuss matters with Bill and David, I'm sure they'd be happy to take your questions. So I'll open it to the floor.
You said that the insolvent as they are received probably falls payment received under Section 27 and be released if it is held by the stakeholder. If the installment mechanism provides that the purchaser pays the installment directly to the vendor, would the vendor be enriched then of receiving the money directly?
Well, Section 25. Well, the question was whether, following on from my statement, that instalment monies had to be paid and held in accordance with the stakeholder provisions. If a contract provided for the instalments to be paid direct to the vendor, would the vendor be in breach of the legislation by retaining those monies? And the answer would be yes, because Section 25(1) requires that any deposit monies received by a vendor in the course of a transaction, other than monies released pursuant to Section 27, shall be paid within 7 days to a stakeholder. The Act doesn't, of course, contain any sanctions for the vendor who fails to comply with that. That's one of the interesting features of the legislation. But in my view, there wouldn't be any remedy. Yes, please.
Just want some clarification on your earlier comment. You said that the stakeholder can be personally liable for releasing the deposit, notwithstanding a purchaser signs a Section 27 acknowledging that there's no condition that's inuring for the benefit of the purchaser, even though the contract might have that condition. Is that still the case? Or has that been tested?
The question is that I said, as I did, that there's a risk to the stakeholder if there's a condition inuring for the benefit of the contract if the purchaser signs a Section 27 statement and the deposit's released. Of course, the point is made that the Section 27 statement contains an acknowledgement by the purchaser that there is no condition inuring for the benefit of the purchaser. The argument would be that the stakeholder would raise, of course, is that there's an estoppel there because there's an express authorisation and an acknowledgement. However, the counter-argument to that would be that the stakeholder, especially if the stakeholder is a solicitor, knows full well what the terms of the contract are, or ought to know. So there would still be a claim, I would think, of some kind, whether it's in negligence or however it would be framed. It would have to be framed as appropriate against a stakeholder, because the stakeholder is not a trustee, but nevertheless, you'd still be fighting pretty hard.
Bruno?
The DeMarco v. Are you aware of the facts that $2,000 was held as a holding deposit and there was a subsequent contract? Was there a reference to say deposit, say 50,000 of which 2,000 had been paid? Because if those facts were there, then I find that decision a bit tricky then, because really it was intended to be the deposit money.
It was not intended to be the deposit.
Well, if the subsequent contract
yes.
had a term that says the price 500 deposit 50,000, of which $2,000 has been paid.
No, well, it didn't say that. In fact, the facts are much more complicated, and I simply can't recall in detail what they were. But one of the issues one of the facts of the scenario, if you like, was that there'd been a couple of amendments to the price made, and it was unclear who made them, and they certainly weren't initialed by the purchaser. So one of the issues was how much money was in fact deposit money to start with under the contract. But the facts as they emerged were that the purchaser had paid $2,000 initially as a holding deposit, and it was held by VCAT in the end that was $2,000 more. That accounted for why the solicitors had $2,000 more than what the ultimate contract provided for as a deposit.
Yeah, I mean, my concern is coming there about the fact that you may have that $2,000, and then if it's an off-the-plan contract, the limit of 10%, you may end up with $52,000. So it's a very important point.
That's right. It is, and I suppose, remember, VCAT doesn't have any precedent value. Then those sort of matters would go before a court. It's simply an indication of an argument, if you like. But it would be an issue that would be very relevant. It was really one of the issues that occurred in the other Everest case. That was one of the things that had happened. A cash deposit was paid $2,000, but in that case it was not just a holding deposit. I mean, it was a holding deposit, but as you say, it was to be credited to the deposit under the contract. That wasn't the case in the DeMarco decision.
Just back to section 27, it's quite typical for, I'm trying to gauge the level of obligation of the stakeholder. It's quite typical for real estate agents in their paranoia when they receive notification from the vendor or the practitioner to say you may release the deposit post serving section 27 either time elapsing or the purchaser acknowledging the acceptance of it. Then they'll go back to the practitioner for the purchaser and just say, is this the right thing? Because I don't trust anybody. They receive confirmation to say, yes, that deposit may be released. Yet, condition inuring for the benefit of the purchaser is one of vacant possession. There's always a condition there, which is arguable. If it all turns to mess, we've got an argument for estoppel, but ultimately is that obligation of a stakeholder higher than that argument of estoppel?
Well, the question is, again, on section 27, whether the obligation on a stakeholder is higher than the comfort that might be obtained by having an estoppel argument against a purchaser who signs a section 27 statement. I think I answered that before, and really my answer was I don't know. As in, I don't have a decision I can point you to, but as I say, my argument would be that if there was a true condition that inured for the benefit of the purchaser, which is, of course, something like the property is subject to obtaining a planning permit within a defined time, subject to finance, any sort of condition such as that.
In other words, a true contingent condition.
That's right, contingent.
Everything in the standard contract is labelled condition. So you have general conditions and special conditions, but that's not what section 27 is talking about. It's talking about a condition inuring for the benefit. That means a contingent condition, such as subject to finance.
Well, that's what both David and I would say. Of course, we don't have a court that said it, but I think that one of the reasons we don't have a court decision on it is because really no one has ever, when they've really sat down and thought about it, been prepared to run that argument to the court, because in my view it's so unmeritorious and it is so obvious that, as David says, that it's talking about a contingent condition which benefits the purchaser. It may not be necessarily one that is only for the benefit of the purchaser. That's another body of law to do with the right to waive it. But nevertheless, it must be, I think, apply to contingent conditions. Conditions in the sense that Justice Brooking used the word in one of the cases on contingent conditions.
David, I just had a question on this extra layer of disclosure on the due diligence checklist.
Yes.
I might be jumping the shadows, but if there was a stuff up with the agent's website was down, the agent turning up to the open for inspection, left the checklist at the office, and a purchaser went ahead and signed the contract without actually having received or had the ability to receive that checklist. Then once to avoid the contract, I take it the sanction would be the, if that was established, the contract would be voidable at the option of the purchaser.
Not what the amending act provides. It's there are penalties for people who, for a licensed estate agent, not to have the due diligence checklist in the CAV approved form, and there's a penalty for not having the due diligence checklist available, and I discussed earlier on what available means. But
There's a penalty under the Act, but
that's
it doesn't
right.
afford the purchaser a right to say, right, because I didn't get it.
There's no avoidance right.
Okay, thank you.
Full stop. For better or for worse. Richer or poorer.
Well, I think we may draw to a conclusion there as the questions have stopped. Please join me in thanking both David and Bill for a very thorough presentation.